More Florida corrupt cops busted for perjury and nothing happens. This time it's Sarasota County Sheriff. But as we know, Punta Gorda, police in Charlotte County Sheriff is corrupt as hell too. When will the feds step in and do a full-blown investigation? Law enforcement after probe. Deputies keep JIP's internal investigation into drug arrests finds them lacking in honesty by Lee Williams. Williams at HeraldTribune.com. For Sarasota County Sheriff's deputies accused of lying under oath about a cocaine trafficking arrest will remain employed, though they were found to have violated several of the agency's most serious general orders. According to an internal affairs memo written by IA Commander Lieutenant Mike Mercurio, former TAC unit detectives James Dilling, Patrick Bassett, James Lynch and Greg Duncan were found to have violated the Sheriff's Office's general order regarding conduct which creates doubt regarding honesty, and the general order concerning neglect. Bassett also was found to have a courtesy and respect violation for the inappropriate way he acted toward a defense attorney. All four were transferred from the Elite TAC Unit, an acronym for Tactical Anti-Crime, to the Patrol Division, and each received significant suspensions, according to Chief Deputy Colonel Kurt Hoffman. Dilling, Lynch and Duncan were each suspended without pay for 120 hours. Bassett was suspended without pay for 136 hours because of the courtesy and respect violation. The Sheriff's Office also has launched an internal affairs investigation of the four deputies' supervisors, Hoffman said. Despite the incident, Hoffman was quick to defend the benefits of the TAC unit. With the exception of this particular issue, they have been very successful in our intelligence-led policing crime strategy, I would say instrumental in reduction of our Part 1 serious felony crimes, which are down 45%. The strength of the TAC unit is its ability to focus immediately on a specific problem, Hoffman said. You can put them on a particular problem and they'll deal with it, he said. They're designed to be able to move quickly on a problem, and they've been effective. 3 Colossus perjury case stems from the arrest of Jose Julian Perez, who was stopped by the 4 deputies in March. Dilling, Bassett, Lynch and Duncan stopped, arrested, wrote reports and gave depositions in the case against Perez. An arrest report written by Lynch indicates that he pulled Perez over in the southbound lanes of Interstate 75 near Clark Road solely because he was not wearing a seatbelt. A sheriff's dog, according to the report, sensed the presence of narcotics in Perez's Chevrolet pickup. Deputies searched the vehicle and found 3 packages wrapped in duct tape that later tested positive for cocaine. The total weight of the drugs was 6 pounds and 56 pence. Perez was charged with cocaine trafficking, a first-degree felony. But reports written by Duncan and Lynch after the arrest, 80 days after the arrest, mentioned that a confidential informant was involved in the case. While deposed under oath, the 2 deputies had never said that an informant's tip led to the traffic stop. This, along with other inconsistencies in the reports and in other depositions, caused officials to become suspicious of the real reason for the stop. The detectives, it was learned, lied about the reason for the stop. Instead of a random drug interdiction stop for a traffic violation, the team knew exactly where and when Perez, with the cocaine, would be driving on I-75 because a confidential informant working with the Drug Enforcement Administration was riding with Perez in the pickup. By lying under oath, the deputies believed they were under the misguided belief that they needed to protect a federal confidential informant, and as such they did not fully divulge their involvement in the traffic stop and the arrest of Mr. Perez, Mercurio wrote in the IA memo. The criminal case against Perez, which should have carried a 25-year minimum mandatory sentence, began to fall apart. Perez, a Brownsville, Texas, native, took a plea deal and received a four-year sentence. During a criminal investigation of the perjury allegations, Sheriff's Office investigators concluded that the 4 detectives lied in depositions and in their official reports specifically because they believed they were protecting the identity of a confidential informant. Internal Affairs investigators referred the criminal case to the state attorney's office for review. Assistant State Attorney W. Earl Varn wrote in a letter that probable cause does not exist for perjury regarding false statements given by deputies during depositions. Following his decision, Varn, a seasoned prosecutor, told the Herald Tribune that the fact they said or didn't say a confidential informant was involved didn't affect the outcome of the case, as there were other independent ways to show that the defendant was in possession of the drugs, such as his fingerprint found on the garbage bags. Internal Affairs probians the state attorney's office declined to prosecute the 4 deputies for perjury. Hoffman submitted a complaint to his department's internal affairs investigators. The colonel spelled out in his complaint that the 4 deputies were accused of violating the department's rules concerning conduct unbecoming, conformance with laws, moral character, neglect of job duties, completion of reports and documents, conduct which creates doubts regarding honesty, untruthfulness in official proceedings and false reports. The internal affairs case was assigned to Lieutenant Mercurio. In his memo, Mercurio wrote that the 4 were each found to have violated 2 general orders, and Bassett was found culpable of the 3rd. Mercurio wrote that the 4 deputies were less than forthright during a sworn deposition with Perez's defense attorney, Varinia Van Ness, when she asked them questions about the arrest, the confidential informant, or how they became involved in the case. Therefore, their actions during the deposition constitutes conduct which creates doubt regarding their honesty as to each of the 4 deputies, Mercurio wrote. The IA chief concluded that there was insufficient information to sustain the other allegations that Hoffman had listed in the complaint. Van Ness said Monday that the incident will likely haunt the 4 deputies for a long time, and could lead to Brady disclosures, information favorable to the defense that prosecutors are required to release about the credibility of their witnesses. While I'm not privy to the investigation, the sheriff runs his department as he sees fit, Van Ness said. These deputies will have to deal with this for the rest of their careers. Hopefully, the state will provide Brady materials to lawyers in every single case they're involved in. All defense attorneys should know, when these deputies are involved, that this situation happened. The deputies' future testimony could be troublesome, she said. I think that any good defense lawyer out there should brief themselves of the circumstances, she said. Certainly credibility is always an issue with any witness. With any trial or motion, this is a hurdle the state will have to overcome when they use these deputies as witnesses. It certainly will come up again. How will they fare? We'll have to see how a jury handles such issues. I think they'll have to explain it. A Brady disclosure, which is ultimately the responsibility of the prosecutors, is something Hoffman too said is possible. The state attorney's office is on notice. They have the obligation of releasing exculpatory material, he said. It's obviously been disclosed in a few cases. I don't see why they'd divert from that, in an abundance of caution. Cocaine seized from Jose Julian Perez, 37, of Texas during a traffic stop on Interstate 75 on March 24, 2016. The case resulted in perjury accusations against 4 Sarasota County Sheriff's deputies. Photo courtesy of Sarasota County Sheriff's Office,